rap was on 135. Oh, I'm sorry, 133. Then 135 draws this parallel, 1.6b2 and 1.6b3. Now that is in the book to show you that. Our goal today is we're finishing up client confidences, and then we're going to move into attorney-client privilege. We're going to take that on. You get silk procedure. And then we're going to start in our next class talking about the lawyer-client relationship. You realize that from these 5 chapters, we will have established the components of an attorney-client relationship. And now, after chapter 5, we're going to be looking at things that can disrupt that relationship, conflicts. And so those 4 or 5 chapters on conflicts will resonate with you because of all of the things that we've done with the attorney-client and the attorney's role. So we started off this course even talking about the wide variety of roles that an attorney has: advisor, counselor, officer of the court, all of these things. And so to navigate all of these complex things, we have to know how these rules function. And we focus on Rule 1.6 because it tells us that we shall not reveal information related to the representation. Very broad category. That's not just what we learn from the client, but anything that we learn that could be confidential. So we have to preserve those secrets, 1.6, or anything that we find out. But then we looked at some exceptions, and we know those exceptions are permissive, the lawyer may. And if you look at the chart on page 116 and 117 in your text, that's what we had in terms of 1.6. And then we started developing how we preserve confidence. We looked at a case called rat poison on page 133. And we were really concerned about assisting this ongoing crime, perhaps, and our duty to disclose what the client had told us. So we had a number of different options. We talked about contact the prosecutor, avoid new charges, plea bargain, go to the client's home and seize the records. We said that's probably not a good idea because we get involved in things that could be detrimental to our professional viability, particularly obstruction of justice. Don't worry about the rat poison in other homes. Just represent Harry, go with Harry and collect the rat poison, remove the harm, or withdraw from the representation. That's probably harsh. But if you look at something like comment 3 to Rule 4.1, it says ordinarily a lawyer can avoid assisting the client for crime or fraud by withdrawing from the representation. We said that's probably a little bit too drastic in this particular case. A number of you said you would just keep working with your client, trying to get him to remove the rat poison and the like. And we finally noted that in the real case, the prosecutor finally obtained a search warrant, seized Harry's records. Harry cooperated with the authorities. A government agency came in and visited the home to remove the poison before any children were exposed. So Harry's lawyer then worked out a plea bargain, and Harry was charged with a single count of manslaughter. That was rat poison on 135. Oh, I'm sorry, 133. Then 135 draws this parallel, 1.6b2 and 1.6b3. Now that is in the book to show you that both of those sections of the permissive revelation under 1.6 are triggered and that they have the same language in them. I want to emphasize this. It says, in furtherance of which the client has used or is using the lawyer's services. Both in 1.6b2 and b3, it says that the lawyer may disclose if the lawyer's services have been used. And so 1.6b2 talks about stopping any future conduct. 1.6b3 talks about, I would say, future, present, and past conduct. Because you have to prevent something that could occur, mitigate, or rectify. And so for both of these, the key is have this language. And that language is in furtherance of which the client has used or is using the lawyer's service. And that's going to bring us to Reese's Leases. Sorry about the opening. And you're going to be really surprised at the outcome of this case. It's an actual case. So we know that we have this mandatory duty not to disclose. It may be permissive under 1.6, and we went through all of those. And we're really looking at the lawyer's duty to prevent his or her services from being used in criminal or fraudulent conduct. Can prevent it, can mitigate it. This is all on page 135. So notice, we want the client to come to us and talk about things that have happened in the past. If you look at the bottom of page 135, if the crime or fraudulent conduct is passed, the client did not use the lawyer's services to assist in that conduct. If the client is hiring the lawyer for representation, that's fine. The lawyer may not reveal that information under 1.6b3. Nothing future is happening, nothing present is happening, and there is no ongoing connection to something that happened in the past. So you see at the top of page 136, you have those 2 examples. The first example, you cannot reveal, and the second example, you may reveal. So the rule is this. A lawyer is allowed to reveal information about crimes and frauds only if the lawyer's services were used in the perpetration of the crime or fraudulent act. We don't want lawyers to turn on their client and tell everything that the client did. And we know that this is permissive. So that helps us set up Reese's Leases on page 145, which is where we left off. Now what about this case? And the big home run question is revelation permissive here? In other words, can a lawyer make a decision not to reveal and everything will be okay? So this is an actual case that happened in New York. It was called Other People's Money, it was OPM. And we set up the fact that, look, this law firm, this is a bad sign too, this is going to show a conflict. We haven't done conflict yet. But notice this, the law firm depends upon its existence on 60% of the business that this client brings in. That's bad. So that's going to color some judgment as well. And we're concerned about these fraudulent bank leases that we learned about. And we ask the question, why does the bank keep lending to a company that is losing money? And we find out that we have counterfeit leases for fictitious transactions on leased cars. In the real case, it was computers, but the same thing. And then we have these phony leases making the business look a lot bigger than it actually is. And then we have our client telling us all of this stuff. How they modify the leases, how they forge the leases, how they create new leases to generate more income. And then on the top of page 147, you have the real problem, fully presented. Now notice the lawyer is told, this is paying your mortgage as well as mine. Of course you know I'm telling you this in the strictest confidence. So attorney wrote opinion letters attesting to the validity of these leases. These go out to third-party banks. The banks rely upon your expertise. Your client says, no, you didn't do anything fraudulent. You're just attesting to what we have, literally, and that's what we have. That's what you represented. You're home free. So we're dealing with this language in furtherance of which the client has used the lawyer's services. We admonish our client. This is risky behavior. We're all going to go to jail. It's got to stop. And our client says, okay, I get it. I know it's bad. We're just going to stop anyway. I was beginning to get worried. We won't fiddle with any more leases, I promise. We think for a moment, and the attorney tells the client to stop. I guess that might be the best we can do for now. So what do we do in this situation? What would you do in this situation? And so what's going to sort of turn how you deal with this is how you characterize this conduct. You're going to be amazed in this case. There's a judge involved in this case that was giving advice. A professional responsibility professor was giving advice in this case. And on some level, they got it wrong. Maybe it's easy for us to say in the classroom what we would do, but it's amazing. You'll see, it seems like everybody got it wrong. Or maybe they wanted to get it wrong because so much money was involved. So how would you resolve this? What would you do? And notice on page 147 we have options. Reveal the fraud to the bank or the district attorney if refuses to do so. So, reveal. I guess we'd be doing that to mitigate or rectify damage that's already been done, and we can't really determine if it's still ongoing, but we decide that perhaps this needs to be dealt with. If you look at comment 8, rule 1.6b3, it says addresses the situation in which the lawyer does not learn of the client's crime or fraud until after it has been consummated. That's clearly our case. Look, this is paying your mortgage. You signed off on this. Now you know. What do you do? Although the client no longer has the option of preventing disclosure by refraining from the wrongful conduct, there will be situations in which the loss suffered by the affected person can be prevented, rectified, or mitigated. In such situations, the lawyer may disclose, permissive. So would you disclose? That's one option. Another option is, this is a lot of money. I'll resolve any doubt in favor of my client. I have undivided loyalty to my client. The client told me they're not going to do it anymore. I believe them. Let's just move on. So do not reveal the fraud and just keep representing. Or do not reveal the fraud but say, well, I can't represent you anymore. I don't feel comfortable with that. So what you do? Reveal. Stop representing. I don't want to be associated with you. I'm just going to leave it alone. Or say, well, if we're very careful moving forward, I accept your contriteness about this unlawful conduct. We can move on together. That was in the past. We're starting a new relationship now. We're moving forward. What would you do? Mr. Mattingly, would you stay in it or what? What do you think?
My initial...
I saw you looking like, like, hey, this is a lot of money. A lot of money. A lot of money.
And I think...
This is about $70 million when we add up everything towards the end. You'll see. A lot of money. So go ahead.
So my initial instinct, I think, would be to want to trust them. They're not going to do that anymore and move forward. But at the same time...
Okay, tell me about that, because we were talking about assessment of the risk. And what would make you sort of say, well, okay, I believe you and we can move forward? This is the bad stuff. And you might be connected to it too, because remember, this is what we're looking at. In furtherance of risk the client has used or is using the lawyer's services. So we could be on the hook for some liability too. So what would make you want to take the risk of trusting the client? I don't know answer anything, just ask. Why would you trust your client?
Just the relationship, the ongoing business relationship as well as the ongoing client relationship, and just the loyalty to the client, I guess. But if they didn't stop doing that, then maybe you could be on the hook for like conspiracy or something.
Yeah.
So even though my initial instinct is to, move forward and let it slide, I think it would probably be best to maybe end that relationship.
Okay. So what's wrong with saying something like this? This is all permissive. 1.6 says may reveal. And there is something in the rule that says if you choose not to reveal when you had the option of doing so, you can't be held liable because you're simply exercising your discretion as an attorney. Is that this situation or is this something more? So what about assessing continued representation and what that means to outside parties, like the banks? You have any concern about continuing this representation that we're talking about the banks? Yes, go ahead.
I think 4.1b might apply.
Okay, now tell me about that.
Because that one basically says you have to disclose to a third person if the disclosure is necessary to avoid assisting a criminal or fraudulent act by your client.
Oh, that's right.
So,
now, go ahead.
I mean, I feel like if they've already borrowed the money, it's going to have to be paid back, and they're probably not going to be able to pay it back without continuing to do this.
That's good. Now, well, don't we have a problem? And this is what we're talking about. This is what is confusing about this rule. And remember I pointed out on page, where was it at? Yeah, on page 143. Even the book says, obviously, this is confusing. We have this discretionary language 1.6 that says may permissive. We know we cannot engage in fraud. We know that we may disclose it. We know that our services have been used in furtherance of a crime or fraud. We know that we have to be honest in transactions with others. But we have this troublesome language. Mandatory says, in the course of representing the client, a lawyer shall not knowingly, and then we go down to letter B, fail to disclose a material fact to a third person. I guess that these loans are shady. And then Mr. Johnson says, when disclosure is necessary to avoid assisting the criminal or fraudulent act by the client. That's good. But then what about this? Remember that language? Unless disclosure is prohibited by Rule 1.6. So it's mandatory but discretionary. How do you resolve that, Mr. Johnson?
So 1.6. I mean, 1.6 is like permissive, so it's not.
So I guess I'm saying, does this sort of let you off the hook? It sounds mandatory, but then it says, unless disclosure is prohibited by Rule 1.6. And then can a lawyer say, well, this is permissive, this is something that's confidential, I have convinced myself that all of this happened in the past, so disclosure is indeed prohibited by 1.6 because I have the duty to preserve these confidence. See how hard I have to work to get to that? And so, I guess that's the question. What about that? In this situation, can you say there's no duty to disclose? Yes.
I don't think so, because first of all, I don't think the client directly says that you're no state. Because the banks recently relied on your representation. Even if what you told them was technically true,
Okay.
that information was still used to commit a fraud.
Okay.
So I don't think you're no state, even if what you represented in terms of what they had was true.
Okay. Okay. So, Ms. Harper, tell me, how are you viewing your client? Why are you less trusting of the client when you say that? You said something that's really interesting. Even though this is technically true, it might be technically true. You just said, yes, they have the collateral. They do. But in order to make that work, you sort of have to look away about the underlying facts about how they got this collateral in order to say that the representations are true. So how are you looking at the client?
I don't trust them as much anymore. This is to them not a big deal, but to me as their attorney, this is a very big deal because that means they lied about underlying facts to me.
Right.
They call it false.
Right, and so notice, we're going to see in Chapter 5, this whole notion of undivided loyalty, that is eroded when you can no longer trust your client. So it seems like, and this is the point that's made on page 143, it seems that even though you have this language, unless prohibited by Rule 1.6, that discretion that the attorney has is limited and restricted by this duty that we have not to have our services used in criminal or fraudulent conduct. It becomes mandatory. It's restricted in these types of situations. So the book even says, this means that in a situation in which the lawyer's failure to reveal, as Harper's pointed out, failure to reveal this to the banks, constitutes assisting the crime or fraudulent act, Rule 4.1 now requires a lawyer to reveal that information. So not as permissive as you think. Not as permissive as you think. So what do you think happened in the real case?
Kept representing.
I'm sorry?
He kept representing them?
Oh yeah. Kept representing them, and there are two law firms involved. These are major law firms. So the first law firm was Singer Hutner. I don't know if they're still around, but Singer Hutner. And they checked with outside experts. They checked with a professional responsibility professor at Fordham, as well as the then dean of Fordham Law School, who was being paid $500 an hour to give advice. And even after they learned that all of this was happening, $60 million of loans were fraudulent, the firm kept silent. And they justified their inaction by Rule 1.6. We can't tell this because to do so would violate Rule 1.6. We would be revealing client confidences, and we know we all must protect client confidences. They gave a benefit of the doubt to their clients' assurances that there was no ongoing fraud, and they continued to close loans on the theory that the fraud that they actually knew about was in the past. So this is just a common scenario where a client, they reason, comes to you for help, everything is already passed, and you're just rendering legal advice to help that client along. Your services aren't being used in anything because everything has already occurred, the argument goes. And so to be certain that this analysis was right, they go to the dean of Fordham Law School and a PR professor, and those experts advise the lawyers that they don't need to check with the leases' authenticity, these lease documents. They had no duty to withdraw the opinion letters to third parties that they sent to the bank, because at the time they sent the letters, they were unaware of the fraud. And so, since the letters had been sent and received in the past, there was no ongoing fraud, and the legal services were not being used in furtherance of that crime or fraud. See how hard I'm working to make this work? Working, making all these arguments. They sound good. And you have people. So when the firm finally resigned, and the computer company was called OPM, Other People's Money, the client then hires Kay Scholler, still a major firm, and they come on board. But the new firm was not alerted to the old firm's ongoing fraud. And this is interesting. Think about when this new firm takes over. And we'll see this later on. When the new firm takes over on these matters, there are some confidences that will have to be shared because the firm will have to analyze conflicts, will have to analyze scope of representation, will have to analyze any number of things when taking on this new matter. But the new firm was not told about this ongoing fraud. So the old firm decides on the advice of its experts that it should not alert the new firm about this propensity to fraud. Quote, the decision to terminate was mutual, and there was mutual agreement that the circumstances of the termination would not be discussed. So that should raise a red flag to you there if you're taking over this matter. These two entities terminate their representation. You don't know why. You just accept it. So eventually, OPM's partners faced criminal charges. They were sentenced to 10 to 12 years respectively. The bank sued the new firm. The firm is obliged to pay a settlement of $10 million. There were other defendants that paid in excess of $55 million. But as far as we know, no disciplinary action was initiated. The dean who gave this advice, I hate to tell these stories because it seems like there's no consequence, everybody comes out okay. The dean who gave this advice later claimed that, well, I didn't have that much expertise in legal ethics. I was just giving a general opinion. He's appointed to the Southern District of New York and later federal court and then later the Second Circuit. So nothing happens there. That's that. And then there was some turmoil about, well, should we change the disclosure rules to the current 1.6 that we have? And there was debate back and forth. But it would take 20 years, Enron and Sarbanes-Oxley, to really prompt us as lawyers to re-envision 1.6 to permit revelation of these confidences. So that is what prompted it. And it took 20 years after this type of case to do that. So not a good look for us. The rest of the chapter deals with limited disclosure. We sort of talked about that. I'm going to jump over to, before we do chapter 4, page 153, the investment project. problem 3-7. So notice the book is sort of giving you some little hints about conflicts. This is a conflicts case. And we're going to go through 1.7, concurrent conflicts, 1.8, specialized conflicts, which is this is an example of 1.9, the former client representation. So we're going to see what you have to look forward and backward when you represent, because you're representing the current matter, but something that you're doing may undo something that you previously did for a client, and that client has the right to expect that his or her or its work will be preserved and not undermined by the attorney who previously represented them. But this last problem in chapter 3 deals with how you handle confidences, and can those confidences be used in a way that is disadvantageous to the client. So, what about this? During the course of our representation, we are inspecting sites for a new plant. So we have access to all of this good information, good confidential information. Our client company's research, we learned that developers are acquiring adjoining property, contiguous parcels of land. They're probably going to build a shopping mall. One parcel of land remains to be sold. Your client has decided not to buy land. So we have this confidential information. We have our client saying not interested. That seems to be okay. The value of this property, of course, is going to go up because the developers want to buy it. And then if you get in on the ground floor as an attorney, you might benefit from this. So notice this is the question. You would like to buy this parcel of land. Are you permitted to do so under Rule 1.8b? And then does your answer change if your client has not yet decided whether to purchase the land? So take a look at 1.8b. Can you buy this land? Yes, go ahead.
I think if the client has decided not to purchase the land, it's fine.
Okay.
If they still haven't decided, I think it would be inappropriate.
Okay.
But if they ultimately decide not to purchase the land and then you decide to, I think that's fine, just because the language says, shall not use information to the disadvantage of the
Okay.
client, and that wouldn't be to the disadvantage if they've already decided.
That's very good. That's good. So, but okay, that's the classroom answer. That's good. Now, real life. Just your client says no, I'm not interested. Is there anything you'd want to do? Not to go overboard, but just to make sure. Because notice you have all the power in this relationship. You have this great law school education. You have your expertise. You passed the bar. You've been studying and working on this business. The person says no, I'm not interested. Now, this isn't a situation where you're in business with a client. But is there anything else you want to do just because the client says, well, I'm not interested? Is there any follow up?
Maybe, well, give a little bit of time just when they say they're not interested and then they would actually like pursue an offer on the property.
Mhm.
But more than that, if, because you kind of garnered the information about the value of the property from your relationship with the client, I would maybe create a document or something for the client to sign. And maybe if you have like a partner in your firm that could also look over it, something so that you weren't the only person saying, oh, here, the client signed this that I wrote, without anyone else looking at it, that sort of thing. But just kind of letting them, well, or I guess kind of acknowledging that they said they weren't going to buy it and then
That's good. So, this isn't a full-blown, informed consent scenario where you're in business with the client and we're concerned about overreaching on your powers as an attorney. It's just making double sure that this person knows what is happening and occurring. You're going to buy this, and there's no disruption in the attorney-client relationship. The client doesn't think, oh, you did a slick one because you got this confidential information because of our relationship and now you're using it. And it's fine if the client says they're not interested. Go ahead.
I was just gonna make some up and see if there's a way to make it an arm's length transaction so that it doesn't look so like you use their information.
Yeah, tell me about that. So I guess the thing is this: how far should we go? Because we have a little leeway. I'm going to compare this with when you go into business with a client, just to introduce it, but we'll be doing that later. But how far should we go when we know that the client isn't interested? Is what we were just talking about enough, or you're suggesting a little more? Tell me.
I'm suggesting a little bit more. Say, I understand that you don't want to purchase this. Here's what I propose maybe, and here's maybe the scenario that could happen. Let them know that they have the choice, and that if they want to make a choice not to purchase it, you would like to, and just let them know how that might work out financially for them. Give them both sides of the story and say, if you still don't want to, I'd like to do it, and to make sure they're okay with that.
Okay, that's good. Okay, that's good. So we both recognize that we have to have some type of conversation. We want to preserve the loyalty, undivided loyalty that we owe to the client, because we would be using information, notice, relating to the representation. That's the confidence for our own good, and we don't want the client to feel like she has been disadvantaged. Information relating to representation. And there's no disadvantage if the client doesn't want it. But what we're suggesting is even if we have the green light, there should be some explanation to the client about how the information will be used. And so you can do this without having this conversation, but the better practical approach is indeed to have this conversation because you're using information related to the representation. Would be to the disadvantage of the client because the client says I'm not interested, but explaining the consequences of what that means. It's sort of getting sort of a preliminary type of informed consent. Go ahead, Mr.
I was just going to ask, would it matter if, the fact that this land, surrounding land, has been sold to a development company, if that was like in the public record somewhere, so it's not like confidential, I guess.
So you're saying, so the status and zone of this land, you get this information publicly, so that would be outside of a confidence covered by a client, and you should be able to go ahead and do it, right?
Maybe.
Yeah, well, that's good. This shows how broad this is relating to the representation because you came into that information by representing the client. So it's not just confidences that you're going to represent the client, it's anything related to the representation itself. So I would say still have that conversation.
In practice, wouldn't that always be kind of considered against the attorney as having that information?
Yeah, tell me how.
Like, you'd be presumed to get any information that deals with your clients from them.
Yeah.
Even if it is public or no.
Yeah. It relates to the representation. So that's why confidences are so broad. It's broader than just me talking to the client and getting this information. Oh, I'm interested in this land deal. Is at Lakeshore. Here's the zoning. That's fine, but you learn things about the filings, about the regulatory framework because of this representation. And if you use this information, it could disadvantage the client. So when the client isn't interested, that's fine. You move on to have the preliminary discussion that we were talking about. If the client does have some interest, I think that changes the analysis. You have to give the client time to make that decision. You can't pressure that client, and you can't go in and use this information to the client's disadvantage. You can't do that. And then there's another wrinkle to this rule as well. And we've sort of been talking about this around the edges. Conflict of interest, current client-specific rules. So I just want to briefly look at 1.8a. So it says it is a bad idea to get into a business relationship with a client. I'm paraphrasing, but it says a lawyer shall not enter into a business transaction with a client or knowingly acquire an ownership, promissory security, or other pecuniary interest adverse to the client, unless. So A talks about a transaction, B talks about use of language. I'm sorry, use of confidential information. I'll just paraphrase. Shall not enter to business transaction with a client, unless. So notice what this says. This says your duty as an attorney will be undermined on some level if you have a vested interest with your client. You have the power, the expertise, and it's going to be an unequal business relationship. And we don't want that. But 1.8 says, unless, okay, if you must do it, there are going to be 3 writings. I want you to be careful about this. So generally, an attorney should not enter into a business relationship with a client. But if you must, it says there must be 3 writings. That shows you how important this arm's length transaction that we've been describing is. So first thing we want a fair and reasonable term in writing. That's the first writing. So if you enter into this business relationship, this transaction has to be fully explained to the client. What the lawyer's interest is, fair and reasonable terms, fully disclosed and transmitted in writing so that it can be reasonably understood by the client. So fair and reasonable terms in writing. Those fair and reasonable terms spell out the lawyer's interest, impact on the client, and it is explained in a way that it can be reasonably understood by the client. That's the first writing. Second writing. Desirability, and some of you hit on this, desirability of seeking independent counsel. In writing. So that's the outside party that can be neutral to tax, give the client an assessment about the viability of this business transaction. And you also have to allow the client time to digest this independent assessment of the transaction. And so we're fair and reasonable terms in writing that can be reasonably understood by the client, the desirability to seek independent counsel in writing, and then the client gives informed consent. Notice that runs throughout this rule. The client gives informed consent in writing. And so informed consent is a deep concept. It's not just, yeah, okay, I'm going to do this. Okay, that's fine. We want to tell the client about the consequences, impact of this type of transaction, what will occur, and clearly define and spell out the attorney's role. So the client gives informed consent in writing signed by the client to the essential terms of the transaction, the lawyer's role in the transaction, including whether the lawyer is representing the client in the transaction. So notice that it wants you to clearly identify any conflicts that could even be on the horizon. It's probably a problem if you're representing your client in a transaction in which you are the business partner, but if you choose to do that, it has to be spelled out. What your role is, how it impacts the representation. So there may come a time you do something really elaborate and you set up this corporation and you're representing the client in quotation marks. You might have to say, I represent the corporation, not you. And that can cause a conflict as well because if it's a closely held corporation, the client will assume that, yeah, we're on the same page. You don't represent this entity, you represent me, don't you? And then the attorney would have to say, no, I represent the entity. So that could be a conflict as well. So that is chapter 3, the duty to protect confidences. One last thing, how would you approach this? This is about on page 154. So we made a big deal about preserving client confidences. In that last page of chapter 3 talks about a study that was done, sort of tracking how often attorneys talk to their clients about our duty to possibly reveal confidences. And it says, it seems clear, however, that if a lawyer might need to reveal confidential information in a particular matter, a client should know that. But it seems like lawyers don't usually tell clients about that duty to reveal confidence. How would you approach that in practice? Because I guess the real concern is if you tell your client that there may come a time where I have to reveal your confidences, that's going to chill conversation. But on the other hand, the client should be aware of your obligations and how that might impact the scope of representation. So how would you handle that? I mean, you don't want to be heavy-handed and say, I'm going to have to tell everything about you, but that's just my duty, and my duty overrides anything that I'll do for you. That would be wrong. But how would you approach that? And the book really doesn't answer that. notice it says the exceptions to the basic confidentiality rule are numerous, complex, and sometimes ambiguous. A lawyer should consider this question of whether to inform a client of potential discretion or duty to disclose confidential information before the first conversation with each client. So how do you approach that? Yeah, go ahead.
Just give us some basic examples. The reason my services to move forward, such as.
Okay. And the highly unlikely event that you would be using my services to, if I would have the discretion to reveal. Yeah. Maybe that's good. So maybe just go through 1.6 B1. Talk about those exceptions and what they mean in terms of representation. That might be good. Now, are you concerned, and this is probably why not a lot of lawyers do it, are you concerned with chilling conversation if you have that type of discussion with your client?
That is a concern. We give them examples, they know what they can't show you. It's kind of avoids that. I thought everything I said is private.
Right. Good.
Maybe also just really emphasizing the broad range of things you cannot disclose, and instead of focusing on these like narrow examples where you may have to emphasize how much the privilege actually protects. Well, might help.
So a lot you would sort of give the things that you cannot disclose, and then how would the client know about the duty to disclose?
I mean, just by lodging it in a broader conversation about attorney-client privilege.
Okay.
Okay, let's talk about our privilege here. And here's all three things. Here's just a few narrow examples,
Okay.
such as committing fraud.
I get that.
In the unlikely event that.
That's good. And so that sort of lines up, and that's a good sort of transition into the next chapter. It sort of lines up with this broad duty to protect confidences and the attorney-client privilege, because on either one of those scenarios, information relating to the representation or information that we want to protect from being compelled in discovery, in either one of those scenarios, we cannot help the client commit a crime or fraudulent act. So there are some instances where the duty to reveal is stronger than this undivided loyalty, and that could be a way to couch it. Good. So, chapter 4, the attorney-client privilege in the work product doctrine. So, you've gotten most of this in extended part, but let me just sort of make a couple of points. So, what do you think, and this is a good way to sort of frame this chapter, since we're coming out of confidences. What do you think the difference is between the confidentiality that we've been talking about and this attorney-client privilege? And some people say, well, the attorney-client privilege is a kind of a small subset of what we have been previously talking about when we talk about confidences. So we have confidentiality, and we have privilege. Well, one thing we've been saying, confidentiality is broad, privilege is narrow. So what about that? Based upon what we have talked about in the confidentiality chapter, how would you compare that with privilege? How would you compare that with privilege? Well, a number of things come to mind. You know, the confidentiality is broad. Confidentiality that we've been looking at comes from the ethics rules. Privilege, evidence. And so we also said that when we talk about confidentiality, we're saying this. We're requiring lawyers to protect confidential information whether or not someone is trying to compel a disclosure of information. So that's broader because we've been talking about relating to the representation. And so our duty not to reveal these confidences comes from the ethical rules, not because we're trying to protect the information from disclosure from some type of process or discovery mechanism. And so that's what makes it broad. We're talking about all information related to the representation that the lawyer obtained. And so if you violate this, you're subject to discipline. Now, how would you compare privilege? You said it's narrower, but out of this chapter, what makes this different than what we've been talking about in terms of confidentiality? Yeah, go ahead.
Well, privilege is more so related to, like you put on board like evidence, so it doesn't have anything to do with facts that your client tells you, it's all based on anything that you have legal advice about.
Okay, good. That's good. So that's good. So you sort of identified information that comes out of the relationship itself, and then there's some type of mechanism and we're trying to compel that disclosure. And we're saying, no, this is coming in terms of representation, and we're saying that neither the lawyer nor client may be compelled to testify in court or for the proceeding about protected communication. And this we're going to see in two scenarios. One is from the representation itself, and that's broken down in the book, and then the work generated by that representation. And so it was pointed out that you have communication between lawyer and client, in which the client is seeking legal advice or legal services. So on some level, this is a subset of confidential information. But it is dependent upon the work that an attorney does. And so here we're talking about discovery practice as the remedial framework to deal with the assertion of privilege. So this breaks down, if we're talking about the elements of the attorney-client privilege, you have several things. You have communication between lawyer and client. You have privileged persons. Communication and confidence. And I'll just put for the purpose of seeking legal assistance. So the book goes through each of these components and discusses the definition of them. And so you see, starting on page 158, what the book emphasizes is that you have to be